So, Joshua, shortly after his arrest, Kohberger was extradited from Pennsylvania to Idaho, and he was held without bail. And it was in early January that an Idaho judge issued a sweeping gag order related to this case, which for a long time kept the details of these murders shrouded in secrecy. So explain for listeners about that order, what it meant, and why it was put in place for this case.
Yeah, the gag order kept the case shrouded in mystery, and it also led to a lot of conspiracies, I think, surrounding the case. I mean, this was one of those cases that, of course, is going to get national attention. You're talking about just a nightmare scenario of 4 college students being murdered in the middle of the night. And for a long time, no one was captured. No one was apprehended. So it just really caught everyone's attention. After Kohberger was finally identified and arrested, soon thereafter, the judge did put a gag order in place. Now, it's not entirely uncommon for judges to make some sort of order about what the parties involved are allowed to say to the media. They're trying to make sure to control the amount of attention. They're concerned about a potential jury pool. They don't want that jury pool receiving too much information, and then everyone has made up their minds and they're all biased before they head into court. So there was that concern. I think this was amplified, though, with the amount of media attention that the case got and the small kind of close-knit community where these murders took place. In Moscow, Idaho, it's a college town, and this was absolutely enveloping that entire town in coverage on this case, and they were concerned that they wouldn't get an unbiased jury. That all being said, the order was very strict. It involved not only the parties, not only the attorneys, but the witnesses, the victims' family members. It was everyone who seemed even tangentially connected to the case was not allowed to talk about it. And so that led to, like I said, a lot of speculation from people, a lot of kind of conspiracy theories starting to mount up. And at the end of the day, I don't know if it helped all that much, to be quite honest.
Now, Kohberger was indicted by a grand jury in May of 2023, and he declined to enter a plea in court, leading the judge to enter not guilty pleas for the charges. What do you make of that?
That was odd. I can't think of the last time I've seen that before. Apparently in Idaho, it's not required that the defendant actually enter a plea. The judge then did enter a plea on his behalf. It seemed like it was more of a formality than anything, but it added to the kind of mystery and, surrounding this case that we didn't even hear his voice for a long period of time. In fact, other than a few short comments he had made, I think that he was completely silent in court up until the day that he took a plea. So at the end of the day, I don't think it changed all that much, but it did certainly add to the mystique of the case that we didn't even hear him open his mouth during that first important arraignment hearing.
Idaho attorney Ann Taylor served as Kohberger's lead defense attorney, and Bill Thompson led the prosecution. What do we know about these two figures and their respective approaches to handling this case?
Starting with Bill Thompson, he's incredibly experienced. He's seen as kind of a local legend in being able to handle the more complex and important cases. And it's my understanding he has handled many cases involving murder where the defendant is looking at the death penalty. And I think he was tasked as being the one most appropriate to handle a case of this magnitude. I mean, I think it's certainly an arguable point to say this is the largest case that's ever come out of the state of Idaho as far as from a criminal perspective. Ann Taylor's also incredibly experienced as well. She is, it's not every public defender is qualified to handle death penalty cases, and she is one of the few in the state of Idaho that is qualified to handle these types of cases that are very serious and involving the most serious of consequences. And she's also very busy. We know that at one point she was asking for more time from the judge to review the voluminous amount of discovery in the Kohberger case. And the judge made the point of saying, well, listen, you've even picked up another death penalty case since the time that you've had this case. So if you're trying to tell me you're running out of time, you obviously have enough time to take on other matters. And it was, a little bit of a jab at Ann Taylor, but I think it highlighted just how busy she is and how qualified she is.
Being a criminal defense attorney is a hard position, and you are often hated by the community. Was there a type of public backlash in this case in particular, which was so horrifying and Such a shock on the community. Did Ms. Taylor suffer any type of public backlash that you know of? And also, did Mr. Thompson, because in accepting in Kohberger accepting the plea deal, eventually it made a lot of people angry. What do we know about that sort of sentiment?
Really good point. This case was, very important to a lot of people. People had extremely strong feelings about this case because it is such a tragic loss of life. And you are talking about young people who had their lives robbed from them in a very brutal way. Ann Taylor is also not a person who is shy from making arguments. She made every imaginable argument in this case, and her zealous advocacy of her client, I think, did lead to some backlash. She was criticized, not so much in the media and mainstream, but more on things like X and other, social media outlets and on YouTube, podcasters. I think people really took aim at her. Part of that, like you said, is going to be because she's representing someone who's seen as a monster and has done this really evil and awful thing. And that the defense attorney, unfortunately, is always going to receive a little of the backsplash from all of that. But then also because she was so aggressive and did not leave any stone unturned, I think a lot of people interpreted that as maybe she was fighting too hard. I will say this, as a defense attorney, that's your job. You're supposed to be zealous. You're supposed to leave no stone unturned. And she felt like she was fighting for her client's life because he was facing the death penalty. Bill Thompson also, many people applauded him and was happy with the work that he was doing. I know that the families were becoming a little frustrated with how much time it was taking to get to trial. But then he, as well, was kind of on the receiving end of some backlash because of the plea. Many people watching this and anticipating and waiting for over 2.5 years for this to go to trial were upset with how it all ended because they felt like, listen, if we're going to have the death penalty, then this is the type of case it should be reserved for. And they were bothered by the idea that the prosecution would, at the 11th hour, remove that penalty and allow Bryan Kohberger to take a plea. As a former prosecutor, I'm sure you and I can understand there are many reasons why you would want to do that, including the fact that he was waiving his right to appeal, avoiding a long and exhausting trial. And we all know trials are not guaranteed. It's not guaranteed that they would have got a guilty out of this. I think the evidence was strong. I think they would have, but there's no guarantee. And there's certainly no guarantee that even after a guilty verdict, they would have secured the death penalty anyways. So I think from the prosecutor's perspective, they had many reasons for accepting the plea that they did, but still, many people looked back on it and thought it wasn't the right thing to do just from kind of their own moral and emotional perspective on the case.
Kohberger ultimately waived his right to a speedy trial. How does that impact the strategies, or did it impact the strategies of both the prosecution and defense here?
It's not surprising that he waived his right to a speedy trial. And in a case of this complexity and magnitude, and when you're talking about the death penalty, his attorneys are going to want every minute that they can possibly get. The only thing that they have at that point in their favor is the fact that they can, to some extent, control the clock, and they need time. They're behind the 8 ball immediately. The prosecution has all of the evidence. They've been doing all of the field work, and the defense is just in a constant state of playing catch up to try to figure out what is the evidence against them. Plus, they had many motions they wanted to file and many things they wanted to argue. And in fact, the defense still wanted more time. They were asking for more time up until a few days before Kohberger entered into the plea. So it's not surprising that he waived time. Usually you'll see that strategy deployed in a case where the defense might feel they can catch the prosecution off guard if they try to rush to trial, but this was certainly not one of those situations.
Early on, the Leda County Prosecutor's Office announced their intent to seek that death penalty. What do we know about Idaho's legal framework in handling capital punishments? Were there any unique aspects of applying it in this state?
Well, one interesting thing that occurred during the course of this trial was that Idaho actually ran up against some difficulties on whether or not they would actually have the ability to enforce the death penalty because of the issues with the drugs and chemicals involved in lethal injection. So Idaho went about changing their laws to allow for a firing squad to be an acceptable means for execution. Then they went about spending, my understanding is, millions of dollars on upgrading their facility where these firing squads could take place. And it was everyone's belief that all of this was done almost entirely in anticipation of this case, that this case was so important and that they wanted to pursue the death penalty. And Idaho is one of those states that takes this type of stuff very seriously. They're not a state that just has the death penalty on the books for the sake of it. They're a state that wants to enforce these executions, and it looked like they had every intention of making sure that if Bryan Kohberger did receive the death penalty, that that would be an actual thing, an actual execution, for lack of a better word, that he would actually see one day. And so it was surprising for many other reasons, but that in particular, that they finally did agree to allow him to plead to something without the death penalty on the table.
How significant was the role of forensic evidence, particularly DNA, in establishing probable cause?
Well, I think you could say that but for that DNA, but for that touch DNA on the button snap, on the knife sheath, this case may never have been charged. I mean, you could perhaps see a scenario where they may have been able to figure out that Bryan Kohberger was involved maybe weeks and months down the road through other investigative work. But the only reason that they were able to apprehend him as soon as they did, and it wasn't all that soon, we're talking weeks later, was because of that DNA. If they didn't have, and the whole case then rested on that DNA. The whole case was about what are the chances that a person whose DNA was found on the knife sheath of a alleged multiple stabbing, what are the chances that that same person would drive a vehicle similar to the suspect vehicle they were looking for? What is the chances that that person would not have a rock solid alibi for 3 o'clock in the morning? What are the chances that that same person would have their cell phone found, multiple times within the 100 yards of the location of the murder home 4 months prior? All of this is circumstantial yet corroborating evidence of the DNA. So in my view, the whole case rises and falls on that DNA. It's that important to their case.
Talk to us about some of the defense's attempts to dismiss the case and their arguments for doing so.
Well, getting back to our discussion on the DNA, their first attack, and I think it was seen as being their best strategy, was they had to do something about this DNA. So they either had to get it legally thrown out of court, or they had to provide some sort of innocent explanation as to why their client's DNA was there. So much of their motion work ahead of time was trying to get this DNA thrown out. And they tried to attack the use of the IgG technology used in this case and the involvement of the FBI and the use of certain genetic websites, ancestry websites, and try to say that all of that was improper. When that all failed, now they had a real problem on their hands. They also made motions for presenting an alibi. They made motions for presenting alternate suspects. And all along the way, at every opportunity, they were trying to fight the death penalty and get that kicked off of the table. So, like I said, it was an exhaustive amount of work on the defense part. And I think the reason why we saw the plea take place when we did is because they had really exhausted all opportunities. They really tried everything that they could to present some sort of affirmative defense in this case. And when they finally lost that motion to present an alternate suspect, an alternate perpetrator, as it's called in Idaho, I think they ran out of options. And I think Ann Taylor turned to her client and said, "What do you want to do?" And I think that's why we received the plea deal as late in the game as we did and as quickly as we did.
She also asked for a venue change, which was ultimately granted due to concerns about media coverage and juror bias. Is something like that difficult to secure in a case such as this one? We've covered many judges that are protective over their venue. And they say, no, this is the community where it happened, and we will find an unbiased jury, and it's not going anywhere. Here it was granted.
Yeah, you don't see it all that often. It does seem like attorneys are starting to request it more. I think that might be a side effect of the amount of media attention the cases are getting nowadays, the way that people consume media. It's not just kind of your local newspaper, but you're getting it through social media and online and everything else. And they just felt like, because for some of the things we discussed earlier, because this was such a huge case with so much media attention taking place in a relatively small and close-knit community, there was a feeling that they just simply could not get enough jurors who had not only just not heard about the case, but not already formed opinions about the case. And they did extensive surveys, too, to try to present that to the judge. You're right. Judges are reluctant. They do want to keep these cases in their local jurisdiction because they say, listen, this crime was committed here. The community here should have a say in it. But ultimately, and I think probably the right decision in this case, the judge decided to move it to a larger county, a much larger county, several hours away, though, however, to allow for a potential jury pool that would not be as affected as the community in Moscow was.
And as you said, on July 2nd of this year, Kohberger ultimately pleaded guilty, an action that prevented the case from going to trial and ultimately spared him the death penalty. What does that tell you, either about the strength of the prosecution's case or the defense's position?
I think it tells you more about the defense's position than it tells you about the strength of the prosecution case. I know a lot of people have looked at this and said, well, wow, that really means the prosecution didn't feel they had a strong case. I don't think this is really an indication of that. I think this is a realistic assessment by the prosecution of the strength of their case. It was a strong case. They had a lot of corroborating and circumstantial evidence, and they had DNA placing him at the crime scene, touching the sheath of the knife they believe was involved in the murder. That's a very, very powerful case. Then they've got other evidence, him searching for the knife online, him searching for what we believe to be a replacement knife and sheath online within days of the murder. This is a good case. This is a case any prosecutor would want to take to trial. But any prosecutor also knows there are outliers, and things can go sideways, and things can go poorly for you. And sometimes, even with the best case going in, it doesn't end up how you think, and nothing is guaranteed. That's always got to be part of your equation in your decision making. Also, this was a case that was going to be bifurcated. In other words, we would have a guilty phase and then a penalty phase. And at the end of the penalty phase, it's not a given that this same jury would say unanimously, we vote to put him to death. It could be one juror who says, I just can't do it. And now you're left with a person who's going to go to life without parole instead of the death penalty. So taking all of that into account, I think the prosecution, it wasn't so much a choice about, do we have a strong case? It was a choice about, is this a good deal? Does this serve justice? For the defense, however, I think because we heard about them entering into this plea so late in the game, I think it is more of an indication of how they felt about their case right before trial was set to begin. Early on, they were trying everything. They wanted to present an alibi. They wanted to present alternate perpetrators. They wanted to attack the DNA. They did everything that they possibly could to mount some sort of defense. And when all of that failed and the walls came completely closing in and they realized they were going into a trial that was going to be very unfavorable to them and likely a jury that would be inclined to give him the death penalty if he was convicted, I think they had a very serious conversation, and it was a plea where they felt like this is about saving your life at this point, not about winning or losing.
Now, as part of the plea deal, as you mentioned, Kohberger waived his right to appeal. However, Judge Hippler noted that Kohberger still has the right to file a notice of appeal, and he cited the Supreme Court case of Garza v. Idaho. Talk to us about this technicality and whether it gives Kohberger any leverage moving forward.
Yeah, the judge made these offhanded comments in court, and it really lit a lot of people's hair on fire when they heard this because everyone's saying, well, I thought he had no right to appeal. What are we talking about here? The case in Garza really talks about a very specific idea, and that is Was it ineffective assistance of counsel for attorneys to not even file a notice of appeal where a client has waived their right to appeal? And the court felt that not even filing that paperwork, which preserves the ability to appeal, that was ineffective assistance. So the judge was kind of saying, well, listen, according to Garza, there is still some gray area here as far as his rights concerning appeal. But in practice, in actuality, and the way that we should be thinking about this does happen quite often where defendants will waive their right to appeal, and they're doing exactly that. There are some small things that survive. In other words, if you can show, like in waiving any right, if you can show that it was not done willfully, intelligently, then you can say later on, hey, I was deceived. I didn't know what I was actually entering into a plea. Putting all of that aside, this is going to be a rock solid situation where he's not going to have a right to appeal. So I think the concerns that may have been launched by the judge making those offhand comments are not entirely validated. If he ever attempted to appeal, if in other words, he got the paperwork together, he put it in an envelope, put a stamp on it, and sent it off to the Court of Appeal, the first thing the prosecution would do is file his waivers of appeal, and that would be dismissed outright.
Kohberger was not required to provide a motive for the killings, and that had a huge impact on the community as well as many of the victims' families. Why wasn't a full confession required in a case such as this one?
Of all the things I think that the prosecution deserved a little criticism about, it was probably this. They can, in these plea negotiations, demand things. They can say, we want to sit down and we want to get some answers. They don't have to, but I think this was one of those cases where why the family members who were upset about this plea deal were most upset was because we didn't have many of the answers. The idea that the prosecution was sitting in court during his change of plea and talking about everything that the prosecution knew, and that still included many holes, like we don't know where the murder weapon is. I'm thinking to myself, well, the man who knows is standing 12 feet away from you. Why don't we know? Why haven't you asked them? And they could have done that. Now, their reason for it, and I don't think it's something that should be dismissed out of hand. It's a good reason. Their reason for it is, why should we trust anything that comes out of this man's mouth? Even the judge said, any answer he could provide is not going to be satisfactory to us. It's not going to make sense because, end of the day, there is no good reason to take the lives of 4 innocent people. So whatever he could have said might have been just more self-serving to him, and who knows if we could have believed it. But I think that the prosecution probably should have asked some things like, why did you target that house? What connection did you have to these victims? Did you intend to murder as many people as you did when you entered that home? Where is the knife? Many questions that are still mysteries that unfortunately will probably remain mysteries from now until he decides to speak.
Joshua, you were in Boise at the time of Kohberger's sentencing. What was that day like, and what sentence did Kohberger ultimately receive?
I have sat through many sentencing hearings as my time as a prosecutor, and they're always very difficult. They're always highly emotionally charged. This was something I've never experienced before. First of all, the amount of strength shown by these victims' family members was just profound. These are people who've suffered a loss that is unimaginable. It's really hard to wrap your head around what they're going to live with for the rest of their lives. And the fact that they're able to put one foot in front of the other and wake up every single day is astounding to me. And then to have the strength to go into court with the entire world watching and pour out their hearts and talk about the loss and the pain that they've experienced. And then for some of them, to turn and look him straight in the eye. I remember when Steve Gonsalves turned that podium and looked and stared this man down, the man that had taken his beautiful girl from him, stared him down in court and told him what exactly he thought of him. And Olivia Gonsalves, who was Kaylee's sister, again, we've heard her words many times, were incredibly powerful. So to me, the resounding strength of these family members was really breathtaking. And it was one of those things where, we all knew what the sentence was going to be. The judge sentenced him to 4 consecutive what they called fixed life sentences in Idaho, which essentially means life without parole. When they say life, it's a fixed sentence of life. So he has 4 consecutive life sentences, plus an additional 10 years for the residential burglary. But he's going to go to prison for the rest of his life, and the judge sentenced him to exactly that. And that was no real surprise to anyone. But it was just incredible to be there. It was the emotion and strong feelings in the air were palpable. And even his family was there. They didn't say anything, which I think was appropriate. But they were there, and they are, as well victims of Bryan Kohberger, and that their lives have forever been changed by his incredibly evil and selfish actions. So it was quite an experience, and I'm glad that I was able to be there for it.
Final thoughts on how this case was handled, or on anything about this case and its impact?
Many times I wonder about the cases that we cover, and you try to figure out why are they important, and why do they catch people's attention, and why do we feel that it's important to cover them? In some cases it's obvious, it's involving celebrities or it's involving political figures, and it makes sense as to why there's this public interest. A case like this, I think the reason why is because it really strikes at the core of our absolute deepest fears. I mean, here you have 4 beautiful young people at the cusp of starting their futures, at the very beginning of becoming adults and starting their lives. And for parents, that is a wonderful and scary moment. And you send them off to college, and you worry about them, and you want them to succeed. And to have that robbed from them in a way that they weren't living high-risk lives, they were having fun. They were having a college experience like all of us had. And in the middle of the night, this coward and this monster comes in and murders them brutally. And then to find out that the person who did it, the person responsible, is not some multiple felon, violent history type person. He's not some person who's been in and out of the prison system. He's a person who is pursuing his doctorate in criminology. He's a person that would not land on the radar. He's a person that comes from a background that there's no clear, obvious signs of what created this monster. When you put all of that together, it really is the stuff that makes nightmares. And I think that's why we're so intrigued by it. It is important because there was a tremendous loss of life, and that is always important. But I think it really scratches at that part of our fears that is the deepest, darkest inside of us that we fear most.